Jane, thank you for speaking to us today. What do you think that the audience got out of today's forum?
I think the focus of today's forum was really emphasising the fact that while compliance programs and compliance procedures are actually absolutely essential in terms of ensuring that you're protecting or managing your risk to the extent you possibly can, that's only the legal part essentially of what's required for corporate cultural purposes. I really wanted to bring to their attention that compliance programs and corporate culture are really interdependent but two discrete things, and while you can actually have a compliance program without a corporate culture, you can't have an effective corporate culture without a compliance program, which requires you to go beyond and above just putting in place the compliance program procedures which are required for legal responsibilities. You need to then look more broadly at the ethical framework in which you're operating as well, which really comprises the corporate culture.
And just taking a step back for a second, is bribery a big problem today?
Bribery has always been a problem, and it's a bit unclear as to whether or not bribery is becoming more of a problem than it was in the past. I certainly remember from years ago in the 80s and 90s where there was always a concern about bribery, but it was considered or treated to be something that was a domestic problem, and so nobody ever really looked at it from an international perspective, whereas now it's recognised as having quite a profound international impact. And it's difficult to say whether or not there is now more bribery, or if it's just that the increased awareness means that it's being reported more often and it's being treated more seriously, and there are more attempts to actually address it both from the supply side as well as the demand side.
How do Australia's anti-bribery law enforcement measures compare to the rest of the world?
Australia has been very, very slow in terms of actually starting to implement its obligations and to start prosecuting under the Criminal Code Act. Australia actually implemented its obligation under the OECD Convention in 1999, and we had our first prosecutions with Security and Note Printing Australia, now 9 executives, in 2011. Over that period of time, the Australian Federal Police have conducted a number of investigations which never actually resulted in any prosecutions, or at least any being referred to the DPP, and there are a range of reasons for that. One of which, I think there are a lack of resources provided to the Australian Federal Police. The other is that the Australian Federal Police really, to be frank, had insufficient skills to really be able to investigate these to their completion. And that's not necessarily a bad reflection on the Australian Federal Police. This is a very different area of law that the Australian Federal Police have been required to investigate, and it's extraterritorial, which means you have to try and often gather evidence that's outside of Australia's jurisdiction, and it's a very complex process. However, I think the delays in actually implementing a lot of these reforms or starting to implement the laws reflect more of a lack of desire by the Australian government to really prosecute this as much as they, I think, would have said that they would when they were first implementing the OECD conventions and then subsequently agreeing to various things like the G20 anti-corruption plan. So we still have a way to go.
And Jane, you mentioned the UK Bribery Act today, which I think is the new kid on the block in terms of anti-bribery legislation. Do organisations in Australia and the Asia Pacific have to be concerned about this act?
Absolutely. And one of the concerns that we have found just looking at Australian companies operating in Australia that have no interaction or otherwise no business in Asia or in the UK is that when they actually want to engage with UK companies now are very aware of their obligations under the UK Bribery Act, are now actually requiring or insisting on very stringent provisions being inserted into their contracts, and also to requiring warranties and indemnities to be signed up by the Australian businesses, just to ensure that from the UK company's perspective, the UK company itself is compliant with the UK Bribery Act. But over and above that, the UK Bribery Act also applies to UK nationals, and Australia has a lot of citizens who are also citizens of the UK. So in terms of Australian companies, if in Australian companies they're operating in Indonesia, just to use that as an example, and there's an allowance under their compliance procedures for facilitation payments, which is legal under Australia's Criminal Code Act, and there's an expectation that facilitations would be paid as a consequence, you could actually be subjecting that individual employee to possible prosecution under the UK Bribery Act because they are also a UK citizen. So there's a range of reasons why Australian companies need to take the introduction of the UK Bribery Act very seriously in terms of their operations here and also in Asia.
Just a final question. To those organisations that are looking to implement adequate compliance programs and measures, what is the first thing they should do?
The first thing they need to do is actually conduct a risk assessment of what their operations currently are at the moment, where they operate, what kind of structure they have. Is it very decentralised or is it very centralised? what they currently have in place. A lot of companies already have in place a code of conduct, but that might be it. So in terms of how they actually implement that code of conduct, they need to start setting out a map of what their current conduct currently is, what they need to comply with, and then start putting in place the compliance procedures, compliance programs, and socialise that through the company as well, so everybody's aware of what their obligation is going to be, and also have the opportunity to start actually providing some input themselves, so there's more of a sense of ownership as to what's happening as a lot of this compliance program is progressing. But fundamental to any adequate compliance program is to make sure that you understand where the risks are to begin with, because if you don't know what those risks are, then whatever compliance program you actually develop is not actually going to directly address those risks.
Jane Ellis, thank you for your time.
Thank you very much.